Okay, we're live. This is Podshoot, a Fine Points edition of Podshoot. You've been seeing a lot of me this week and also a lot of our commentator, Bruce Fein. He is an esteemed constitutional scholar, lawyer, and author, and he has been generously offering his time this week to give us commentary on the Supreme Court opinions as they are being released. These are the final opinions of the term, some of them very, very important. I understand, Bruce, though, one of the big opinions that we're waiting for having to do with whether Trump is going to enjoy presidential immunity in a criminal prosecution against him. That opinion has not been released today in advance of tonight's debate. Is that correct?
That's correct, Amy. The court issued 4 opinions today. That leaves 6 on the docket. At least at present, there's only Friday scheduled for opinion day. 6 is kind of a large number. They may push the term into Monday or Tuesday of next week.
Okay.
But I do agree that they wouldn't want to issue this opinion on Trump because if it's before the debate, it clearly would be raised in the debate, and it would then intermingle the court's decision with politics, which is already too much happening, at least in the minds of most Americans.
Yeah, I mean, I've seen a lot of commentary about the Murphy versus Missouri opinion released yesterday and how politicized it seems. So many people were making it a kind of a more extreme case that the court was siding with the Biden administration. I'm sure the court would say that it was not siding with the Biden administration. In fact, it wasn't ruling on the substantive issue. But you and I discussed yesterday, and people could go ahead and check out yesterday's edition of Fine Points. But we were discussing the fact that while no, they weren't explicitly ruling on the substance, that their position on standing did make it less likely that people were going to be able to assert their First Amendment rights in similar situations in the
Well,
future. Is
that's
that right?
true, but when you go down to politics, Amy, 2 of Trump's 3 appointees were in the majority. Trump's
Right.
appointee wrote the opinion. So it's more difficult than to argue this was a politicized decision.
But you know where the people go with that argument, right? Then they say, well, then she betrayed him and somehow, right? I don't, people get so political about these things, but as I understand our conversation yesterday, whereas the court's positions on standing end up affecting our substantive rights, and I've seen more or less extreme assertions of this. They're not rulings on the substance themselves, but they can have effect on the substantive rights and
The
the
impact
exercise
can
of
be
them.
very
Yeah,
important. For
yeah.
example, I believe this decision saying this moot, in light of the fact that COVID is gone and whatever, you're never going to get a case. It's not going to ever get to the court. They
Right.
basically said it's hard, it's controversial, it's divisive. Hey, if we find no standing, nobody wins, nobody loses, and it'll be 100 years before we get another COVID. So let the court worry about it then. I'm not sure that's the way that the law is supposed to work.
And I'm
It's
also
more
not sure
recent.
that's the way the facts are going to work, right?
Yeah, yeah,
What is the next COVID? Is it the bird flu? Is it climate catastrophes, right?
yeah, yeah.
So, yeah.
Yeah, well, sure enough, and because the Congress has refused to define what a national emergency is, you're getting statements now out of the Surgeon General. Social media is a national emergency. Young people are getting addicted. You need warnings. It's like cigarette warnings. I mean, the regulatory state is really totally out of control. Um, and
Yeah, and
this,
trying to put it in check when standing is such a difficult hurdle to overcome
yeah.
is going to be even
And
harder now.
that's why, Amy, that's why, and I wrote this book called Congressional Surrender, which I urge everybody in this audience to read, is precisely because Congress doesn't have a standing problem. They can cure all of this stuff, hold hearings, pass the law, correct it. They could prevent the Surgeon General from doing that tomorrow. Don't have any authority to do that. But Congress has turned into an ink blot. to be candid. They're there. They're irresponsible. No, we don't want to decide anything because we could be primaried because we took a position on an important issue. And then virtually no hearings. And
Right.
that's where the wrath or the disappointment of the public ought to be aimed. I complain, well, Biden does things, Trump does things, he's overreaching. But they're overreaching because Congress lets them overreach. Congress has all the authority to stop it instantly, but they do nothing. The Democrats will support Biden, the Republicans support Trump. There's no institutional integrity. And as a consequence, rights get forfeited, in part because the Supreme Court does have these standing rules that make it very, very difficult to actually get an issue before the court on the merits.
Right, right. So turning to what opinions the court did release today, what should people know about what was released by the court? Earlier, I had seen a couple headlines in the New York Times about two of the opinions that they seemed to think were more important. What's your take?
Well, let me just briefly summarize the four cases. First, the court said that the Environmental Protection Agency didn't have authority to impose what they call good neighbor policy plans on states who were seeking to regulate ozone to prevent various and sundry respiratory illnesses. And good neighbor policy is an abbreviation, if you will, for controlling ozone in a way that wouldn't have it blow over your state line and cause another state to have an ozone problem. So when you're trying to implement a good neighbor policy, you're trying to prevent one state from handing off its ozone problem to another. And the court said that the EPA did not have authority to impose a federal uniform standard on 23 states. Now, in the larger jurisprudential sense, Amy, this is part of a longer term endeavor by the court to rein in what I call regulatory excesses. And the excesses are there largely because Congress writes these open-ended laws that act in the public interest, which means whatever you want it to mean. And the court has been now very reluctant to interpret these regulatory laws in a way that could have seismic effects on the economy, on the way in which states operate, unless it's very clear in the statute Congress intended that. And so this falls into that regime, and it makes it, I think makes it more likely that if we are going to have these regulations imposed and hamper a customary free choice and free market, Congress has to decide it. And I think that's a good sign. You can't get away with by giving it away to the regulatory agencies anymore. They're not saying that Congress can't enact this, but they have to vote on it. And that means getting a consensus. You see, one of the reasons why, Amy, that the Congress is a more reliable institution to do things sensibly than a regulatory agency is structure. In Congress, you need to get the House to approve, the Senate to approve, committees to approve, whatever. You have representation and views from all sections of the country, rural, urban, suburban. Some are manufacturing areas, some are high-tech areas. So you have different viewpoints that have to be compromised and discussed and debated before you can reach a result, because ultimately you have to come up with a majority. You can't get anything done in Congress without a compromise, moving what I would call towards the Aristotelian mean in order to get that consensus, because you have 435 in the House, 100 in the Senate. What happens when you shift the scene to the executive branch? You just have one person. There's no requirement to debate, nothing. It's not open.
Or the administrative agencies, where it's just a bureaucracy, which isn't even connected with reality half the time, right?
Yeah, right. So it's one. I mean, if you go to the agencies, I've served in them. It's okay. Sometimes you have 3 members or 5, but it's not 535. No. And so the consensus requirement, it breaks down. You just need one. And so one administration can wildly veer to the right, another wildly veer to the left. And most of the time, it lacks, in my judgment, the kind of moderation and breadth of interests that are balanced than when you get in Congress and you force Congress to act and you tell Congress, basically, in our system, if you can't get together, then you can't do anything. You just leave it alone. We don't want you to get in unless you're able to balance all the interests fairly. Otherwise, it's better to do nothing. And this decision today
I'm
was
listening to this though, Bruce. It's like, first of all, we just saw Congress act what I would call dysfunctionally in renewing Section 702 of FISA. I've had a conversation with Justin Amash, who has quite a number of complaints about the way that Congress does operate, so that this idealized debate that you're talking about that can happen where all viewpoints are expressed from all corners of the country, that breaks down under the current regime, where the rule that they pass at the beginning before they even consider a piece of legislation actually dictates what views can be heard and voiced and what amendments can be considered, etc. So, I mean, you would concede that there are some dysfunctional aspects of the way even Congress operates today, right?
Well, sure, Amy. There are imperfections in everything because we're dealing with human beings. But the issue is, let's not make the cure worse than the disease. And
Mm-hmm.
let's think specifically about 702. I mean, FISA, at least it's got far more debate and focus and almost was narrowed before Mike Johnson flipped for
Right.
ulterior motives, and because he's a very strange House Speaker who depends upon Democratic votes to lead a Republican House. That doesn't happen very often. And I do believe, even spurred in part by the information, the focus on the Espionage Act and spying by Julian Assange plea, that maybe the next time around we'll get something. This was a closer debate this time than before. I mean,
Right.
right after 9/11, you couldn't get anything. Silence.
Right.
And moreover, if we look at something earlier with Ed Snowden's disclosures, despite the fact that the intelligence agencies, the intelligence committees, were calling him a traitor because he really exposed they weren't doing any oversight. They did ultimately amend the statute. So there is at least some movement. Now, it is ideal? No, it's not. But it's certainly better than the alternatives, which is, okay, hand it to you. Who else is going to oversee this? We do have an alternative, however, or supplements called Executive Order 12333. That's a unilateral order of the president saying this is how you can spy for foreign intelligence purposes. We have no clue what's going on under it, other than when you describe foreign intelligence, it can be anything under the sun.
Mm-hmm.
So at least there's some debate on FISA. I would wager, Amy, I don't want to, not trying to be pedantic here. Most of your audience never even heard of Executive Order 12333.
I think I'd only heard of it recently myself, Bruce. So,
yeah. No, I understand. I'm not faulting anybody because Congress doesn't do any oversight. The media doesn't write about it. So unless you're kind of an expert in the arcane elements of executive orders, you wouldn't know. But I'm saying that's the alternative to at least having some debate over 702. And they don't have any debates, no hearings at all in 12333. It's just the intelligence. There's 17 intelligence agents just together. Okay, this is what we need to do.
Yeah. So this will be part of this, I've got this fantasy episode of Fine Points we're going to do in the future where we're going to really dig deep into the warrantless surveillance issue. It comes up each time practically that we have a conversation. But so with the EPA ruling, this is the court chipping away at an administrative agency's ability to cripple the economy in this particular way, to regulate what the states do with regard to regulation of ozone. And you would say that that's a positive sign for freedom.
For accountability. I don't say it's necessarily a positive sign for freedom because the court didn't say Congress could do the same thing. Okay, so Congress could, and it wouldn't be unconstitutional. I think it's less likely Congress will do the same thing. but it's a strike in favor of accountability. Hey, if this is going to be done, it has to be done by representatives. We
By a
have
representative who faces the
a re-election, yeah,
voters
and can
and
be
how,
voted
yeah,
out of
yeah,
office. Exactly.
yep,
And then they
yep.
may change
Okay,
the statute the next time around, depending upon
okay.
what the voter sentiment is. Because you remember, just to say Congress ought to decide doesn't mean Congress is always going to decide in favor of freedom. Congress
No,
can
of
do
course
dumb
not.
stuff, but
Yeah.
it's less likely to do dumb stuff than the executive branch, for sure. And for that reason, that's why the founding fathers and the architects of the Constitution said, yeah, the legislature is not perfect. They'd be grasping for power, but we don't want compared to a despot, a monarch. No way. We choose
Right.
Congress anytime, as stupid as it can be. And that's what we're talking about here, the least worst alternative. But on that same score, Amy, with regard to the regulatory state, the court also, in the SEC versus Jarkey case, said that the SEC cannot impose civil penalties for violating the securities laws for fraud unless there's a jury trial. You can't just do it administratively.
Mm,
You have to go to
okay.
a court and have an Article 3 court adjudicate this. Again, chipping away at the regulatory state. And here I think we should pause and understand how I believe irregular the regulatory state is, in the sense that it combines in a single agency the power to issue rules, right?
Mhm,
Legislative power, the power to execute the rules by enforcing
mhm.
them, and then they adjudicate the rules. That is, combines the legislative, executive, and judicial power in one agency.
No checks and balances. Forget it. Yeah. Yeah.
That's what the framers called the very definition of tyranny. There's a
Mm,
Montesquieu they borrowed from the spirit of the laws, saying you can't have these combined functions and avoid tyranny. So the court says if you have a regulatory prohibition that kind of matches a common law prohibition, you can't adjudicate this, within an agency. You have to go to court. It doesn't mean they're going to lose, but it obviously diminishes their clout and ability to sort of hold a sword of Damocles over those people they regulate by saying, got to come in here. I haven't looked at it, Amy, the
mhm.
statistics, so I'm kind of speculating. But how many times you think an agency, when they spend resources issuing a rule, they spend resources investigating and say there's probable cause to bring an agency enforcement action, and then going to say, oh, we got it all wrong. We just wasted our resources. We were really stupid.
Yeah, there's going to definitely
That's
be
the
a
obvious mistake
presumption
in
in
that.
favor. Yeah.
Yeah, yeah.
Yeah.
Why
Yeah.
would they do that? They had already found
Okay.
probable cause.
So you said that the court's ruling depended on whether the supposed infraction by the person or entity was similar to something that existed at the common law.
Yes,
So is that the way that the court narrowed it, such that the agency could still enforce
some
fines with
different.
respect
Yes,
to other rules that were different? Okay.
yeah, that were different because the Seventh Amendment, which what they relied on, says the right to jury trial at common law shall not be abridged. So
Okay. Okay.
that's the text of the Seventh Amendment, and they weren't going beyond the text. So you have to find some kind of analogy. So there not doesn't mean that there won't be any unique features of the regulatory state that had no ancestry tracing back to the common law, where they could still do um, an internal agency enforcement action without the court. But it's
Oh.
emblematic of the effort of the court to try to rein in the regulatory state. And this causes me to make a comment upon one of the cases that remains. And it addresses a case called Chevron versus National Resources Defense Council, the so-called Chevron case in 1984, in which the court, through Justice John Paul Stevens, said that agencies that interpret their own statutes should be given almost conclusive support unless it's just a wacko interpretation. So, and you can imagine,
1984, you said, released in 1984.
yeah,
Which
1984.
how fitting is that?
Yeah. George
right?
Orwell, right? George
Mhm.
Orwell's
He had his birthday a couple days ago, apparently too. But
1984.
yeah,
Yeah.
yeah.
So,
So what's the case that's outstanding that would touch on this doctrine, this so-called Chevron doctrine? I've heard it, spoken about quite a lot lately.
yes, I don't know. I right now I can't remember the title of the case, Amy, but it's
Okay.
one of the six left that we'll get.
Okay.
Um,
Okay.
but that's what I think. It's almost
Mhm.
certain in my judgment that the court will abandon Chevron and say, "Hey, courts decide issues of law." I mean, it's we all know as lawyers, you even go up on appeal. If it's a pure question of law, the court decides it. They don't give any deference to anybody else, right? And so,
It
in
sounds like these two cases that you just talked about chips away at that principle a little bit, at least, right? Or no?
well, a little bit because they were overruling regulatory. I mean, they were agency interpretations of what their authority was. Correct. That's
Right.
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 Already, but as we know as lawyers, that if we're appealing, a trial decision to the Court of Appeals or up the Supreme Court, if it's a pure question of law, it's de novo review. They don't give
Right.
deference. They just
No.
what's the correct interpretation, right?
Yeah.
And in the Chevron case, what's at issue? You're just interpreting the law. Why you you know that is they're giving more deference
More
to
deference to an
regulatory agents than they
agency.
do to
Yeah.
judges. Try to,
Or to legislators, right? Because I think
or the
the
legislators
denote
as
right,
well.
right,
Yeah,
right.
yeah.
So, okay, so, going back to the SEC ruling that you just talked about, in
To
my
us.
view, I mean, in my view, if you look at it from a perspective of individual rights, and I understand this is not law, this is just a normative judgment, there should be more accountability, more, um, you know, uh, review, right? A higher standard of review that or I guess you'd say a lower standard of review. You should give more review, more scrutiny to something that didn't exist at common law, because common law was quite good at ensuring that individual rights were upheld and protected. So, from a normative standpoint, the court's ruling that you described actually seems like it's going to give more free reign to the regulatory agencies in cases where it's making rules that had no corresponding principle or doctrine or rule in the common law, right?
Well,
Um,
it's true, but they can't
yeah.
make up. They have to at least point to, like in this case, the SEC, Amy, it was securities fraud. Well, common law fraud was common law. The securities
No,
fraud is
sure.
built on that. But in other cases, ordinarily Congress would have to at least provide some baseline authority. Because
Right.
the agencies just can't make up, hey, we want it to be a cause of action, to not wear a mask when you think you have COVID or something like that. Congress would have to act.
But
So it doesn't
we
it
need a
gives them license.
complete we would need a complete repudiation of this Chevron doctrine to make sure that there's adequate scrutiny of administrative agencies when they're doing something that doesn't correspond to the common law, though, correct?
That's right. You wouldn't give no
Yeah.
deference to their statement whether this is or is not a common law cause of a related cause of action. By the way, just for our views, the case on the Chevron is Loper Bright Enterprises versus Raimondo. If anyone wants to look at it, if you want to go on the Supreme Court's website, you can see the briefs that have been filed. But Raimondo is the case that
Okay.
raises the Chevron
I'm
doctrine.
looking forward to hearing about that one. Yeah.
Okay, the other two cases, one was actually not an opinion on the merits. It's kind of unusual. It was on an application for a stay, and it came from Idaho. And I kind of try to unravel this so that the audience can understand. There's an emergency federal statute that provides that if hospitals have federal funds, they have to provide emergency aid to women who are in cases of emergency, and issued an interpretation saying that means an abortion can be an emergency. So you have to provide abortion services. For example, the mother's life, mental health could be in danger. And um, Idaho passed a law that basically said there are no exceptions to abortion
Mhm.
limits. Um, and they challenged the authority of the federal government, the Health and Human Services, to require that emergency abortions be handled, in Idaho hospitals because they receive federal funds. And initially, the federal district court said that the federal law preempted the Idaho limitation on abortions. Then the case came up to the U.S. Supreme Court, where Idaho wanted to leapfrog over the Court of Appeals and get direct review.
Mm-hmm.
And the court, and there was a request for a stay of the decision.
Right, because it was an injunction basically preventing this
Idaho
from being
enforcing
enforced.
its law.
Right.
And so the court then today they had granted the writ of certiorari. That is, they decided that they would leapfrog the Court of Appeals and take the case directly. So today they changed their mind. They said the writ of certiorari was improvidently granted. The stay was improvidently granted. They sent it back down to the trial court again to hold a decision on the merits because the stay was at the preliminary phase. So the result is that it leaves Idaho's law unenforceable during at least the initial pendency of the challenge to the interpretation that federal law requires that they provide emergency abortions. The other case is a little more arcane. It was under bankruptcy law where we all remember Purdue Pharmaceuticals and the Sacker family. They made lots of money off of, I guess, OxyContin, pain relievers. Then we had all the opioid cases resulting in staggering amounts of damages and judgments because of the malprescription, if you will, of opiate treatments, which caused huge addictions and created opiate crisis. We're still seeing them today. And the issue in the bankruptcy case was whether a bankruptcy court could shield not only the company that was making the OxyContin, but the personal liability of the Sacker family in trying to resolve their bankruptcy proceeding, which requires paying creditors and damage judgments and whatever. And the court said, no, you cannot have a non-debtor because the individual members of the Sacker family had not filed for bankruptcy. And the court said you can't shield a non-debtor in a bankruptcy proceeding concerning a debtor unless the creditors agree that you can shield them. Because in this case, the Sacker family was so interrelated with the company, you could argue that you could, what we call, pierce the corporate veil, and they could still be liable, at least in some respects. So that's kind of a more narrow case. It's not likely to occur again. But so we now have, Amy, 6 cases left. And I know at least 5 of them are, if we just run down, are very, very important. We have one of the cases concerns whether the January 6th defendants, rioters, who stated goal was to prevent Mike Pence from counting the state certified electoral votes. Was that a, quote, an obstruction of a congressional proceeding with the meaning of a federal prohibition? Or does the obstruction have to require some destruction of documents as opposed to just counting votes? And if I was at the oral argument, and certainly there was some skepticism of interpreting the federal criminal statute, and you ordinarily have a doctrine of lenity, says ambiguity, you interpret it in favor of the defendant.
Right.
If they rule that the statute is not as broad as the government was arguing, then a lot of convictions, there have been over 900 January 6th defendants, will be lifted. But most of them had other violations as well, trespass on their
Sure.
property, committing violence.
Right.
It wasn't simply, it was only one of their counts was um, obstructing a congressional proceeding. I couldn't give you a number that would go free immediately because they'd had no other conviction. But that's one case. Then we have what you pointed out, the presidential immunity case, which will basically determine, are we going to have a trial of Trump in the federal court here over January 6th before November or not?
Mm-hmm.
Then we have the Chevron case that we just discussed. And then there are a pair of cases concerning efforts by Florida and Texas to control what kind of editorial or censorship function social media can use in deciding whether they want to either delete or block messages. You could say they're anti-Republican, anti-Democrat, or something like that. So
Mm-hmm.
those are 5 cases, and my belief is that, I suggested, I think yesterday, the idea that you could come up with this argument that social media, when they receive a certain size, are the equivalent of a public square. So they have to be philosophically neutral. They can't be viewpoint focused. They could say, obviously, that you're not viewpoint focused when you say, if you can't post illegal things on our platform. You can't threaten people to kill them. You can't sell drugs. You can't use obscenity. Those kinds of things. That's viewpoint neutral. You just say you can't do anything illegal on our platform. But when you go beyond that, you could say a reasonable time, place, manner. You could prevent somebody from having too much or posting too much. Maybe that doesn't exist when you've got clouds
Spam, for example. Yeah. Uh-huh.
like that.
Right.
Uh, but I don't think right now the court is likely to go that far. I think they're likely to say these provisions are unconstitutional, and
And again, to be clear for everybody, there are Texas and Florida laws by which those state governments were trying to tell social media platforms, in essence, there's differences between the two laws, in essence, that they have to be viewpoint neutral in their so-called content moderation. A lot of platforms choose to throttle or even, prohibit content that the First Amendment would allow, right? The First Amendment would protect,
if it's
and they
if from
and
government oppression,
right,
yes.
right, and they do that as part of their content policies. And what Florida and Texas were trying to do, both because they perceived that there was bias against so-called conservative viewpoints, is to try to tell the platforms, you have to be viewpoint neutral, you have to behave in effect as a town square. And you're thinking, Bruce, that the Supreme Court is going to say that no, states do not have the authority to mandate social media platforms to behave like this company town. Is that
Or
right?
the federal government. Yeah, I think, and I don't think they're comfortable enough with knowing the ramifications. But let me try to give this example, Amy. Maybe it's a little simple, but I think it underscores, what the issue is. Say that, in your home, you say you can come in, if you're a Democrat, and say really, really, really great things about Democratic candidates for public office. But I'm not going to let you come into my home if you're a Republican and want to say good things about Republicans. Now, are you violating the First Amendment? Obviously, the speech that you're regulating is customarily protected. I mean, you can say these things on the sidewalk for sure, right? Or in the park.
Mhm.
But hey, it's your home, your property. You get to decide what ideas you want to associate with and what not. And this is where I think it becomes, very challenging. Just like there's a First Amendment right to speak, there's a First Amendment right not to associate with speech you don't like. It goes
Right.
back, long, long time ago. The court case called New Hampshire versus Piper. The court held you couldn't compel New Hampshire automobile drivers to have a license plate that says "Live Free or Die" if they didn't believe that,
Mhm.
because they were so. Well, I don't believe that New Hampshire stands for "Live Free or Die." The court said no, you can't force them to carry a message they disagree with, and so they built on this idea that you can't compel somebody to associate with speech with which they disagree. You have a right not to associate with that kind of speech. And so if we try to analogize, say, the homeowner situation that I just described with the social media company, says it's our company. We don't want to associate with that speech. That's what we want to do. If other people want to speak that way, make their own company or go out on sidewalks and parks. That's their business. But you can't force us to associate and give platforms to viewpoints we don't like. And we're not
Right.
going to give them to Nazis. We're not going to give them to the Chinese Communist Party. Or we're not going to give them to white supremacists. We're not going to give them to radical Weatherman Underground or something like that either. So that's the issue. And sometimes it's hard to know, how much compelled speech is at work here. Let me give you another example where I think was a little more difficult, where when the government still had a don't ask, don't tell policy for recruitment into the military. They had under a federal law, they had a right, if universities receive federal funds, to permit the armed forces to recruit on campuses. And the campuses said, hey, wait a minute. We don't agree with don't ask, don't tell, so we want to keep the recruiters off the campus. And they argued, well, to permit the recruiters on the campus made it appear as though we were endorsing don't ask, don't tell, but we don't endorse it.
And again, explain what don't ask, don't tell is for people who don't understand.
It means for those people who were homosexual, lesbian, or gay in the military would not ask what your sexual orientation was, and you don't tell, and you could stay in.
Yep.
That was the policy, that they weren't going to expel anybody, but we won't ask you what your sexual preference is, and you're not going to tell us. Let's just move on. That's what that's about. Now, today, it's totally different. They've eliminated that limitation, if you will.
Right.
So the universities said to permit the armed forces recruiters on campus would be at least create an optic suggesting we're endorsing their views. And we don't, because they were opposed to don't ask, don't tell. And the court said no, that if people it's sophisticated enough, they know it's an academic institution, and that this is just right of toleration, just like the university has students who might say a lot of crazy stuff. Nobody thinks because a student attends a university, anything they say, the university endorses, right? They got somebody that got 40,000 students. And therefore, at least the association of the university with the don't ask, don't tell policy was too remote, to trigger First Amendment concerns. But I give you that as an illustration of what's kind of that issue in this kind of case.
Yeah, I mean, I can imagine in a case like that, their case would be stronger if, in addition to saying, okay, you have to allow recruitment on campus if you take federal funds, that you as a university cannot make any public statements about the don't ask, don't tell policies of the military. But I'm sure that wasn't the case.
No.
Right.
Yeah,
Exactly.
that would clearly be a violation of
Exactly.
Yeah, that's right. I mean, you have a First Amendment right to petition government for redress of grievances, right? That's every bit as strong as the free speech. So how do you petition the government for redress of grievances except criticizing government?
Yep.
It's not going to end by spontaneous combustion.
Okay, so your prediction will be that the Supreme Court will uphold, the social media platforms' rights to so-called curate content on their platforms the way that they see fit. They have a First Amendment right to do this. And I remember in reading about the oral arguments for these cases, these are net choice cases, if I recall correctly, that the number of the justices were talking about this First Amendment right. And my question for you is this: suppose they do this, they uphold the platform's rights to curate as they see fit, and Florida and Texas can't require them to do it the way that they say. What will be the implications for Section 230? And this is a tension, again, that some of the justices did state explicitly when they were having these oral arguments, that yes, on the one hand, you could see that they have this right, but doesn't that also sort of weigh against having immunity from liability for their choices if they're saying that they have a First Amendment right just as publishers do, right?
Yes, but I think, Amy, so it's a wonderful insight. I think the explanation is as follows. Section 230 of the Communications Decency Act is not a right under the Constitution that the social media enjoys. It's a right that Congress gave and Congress could take away.
Mhm.
Um, and it may well be that as a consequence of the court's decisions, Congress, and you know that there have been statements urging a repeal of Section 230. In fact, you know that idea in the case that we talked about, the Murphy and Missouri case, where the government was trying to kind of weigh in to influence what the social media was doing, they held in the background, we might want to get rid of Section 230 if you don't do what we ask you to do, right?
Mhm.
So it
Mhm.
is a statute that is grants this liability protection, but they don't have any right than social media to demand that it stay there. Congress could repeal it tomorrow. There'd be no First Amendment issue. I've urged that it be repealed precisely for the reasons that you've indicated. If you are a newspaper, if you're a broadcaster, you aren't immune for liability if you publish defamatory statements, even if it's third party repetition. That's a republication. You have to buy liability insurance, and you are and you are making and you're exercising it see some control over what appears in your newspaper, what goes on your broadcast, but it's your choice. You wouldn't have to. You could make it, well, we'll just have the first 10 people come in, and you can do your own skits. But they are subject to liability, and of course they have liability insurance, and these BMS have huge amounts of money. They can buy liability insurance. And the fact is, these broadcasters and newspapers aren't going out of business because of defamation claims. Even look at Fox is thriving. They paid a 787 million claim brought by Dominion voting machines, right?
Right,
So
right.
it's just this concocted this idea that, oh, without this immunity on 230, all the social media would disappear tomorrow. Oh, really? You're going to tell me Meta's going to disappear tomorrow without this statutory protection? The reason why, in my judgment, that the statute does not get repealed is because, kind of like the Sorcerer's Apprentice, that Congress has created, these behemoths with so much money and so much
Mhm.
political power and PAC money. They won't touch it, not
Right.
because they shouldn't, but hey, we're going all those campaign contributions going to dry up. That's what this is
Yeah.
about. Yeah.
No, I mean, in my view, the principle at the root of Section 230, this immunity, is fine, and not to be no pun intended there. But it's good in the sense that if the platform is just behaving as a bulletin board, if it is just allowing content and it actually doesn't perform as a routine business practice anything that would give it special knowledge of the content that is being posted by these users. Again, this is user generated content. They don't have any special knowledge of it through their regular business procedures, which are reasonable. And at the same time, they aren't doing anything to either elevate the reach of particular content, or they're not trying to demote it in any way. Then yeah, they shouldn't be treated the same as publishers. That's different. Any tort law would say that the culpability should go with the level of responsibility for the harm that is caused. And so, yes, I think it's different if you are just, putting up a platform for somebody and you are behaving reasonably within standard, ordinary business practices that are prudent, et cetera, for that type of business. But what Congress decided was that in order to enjoy any immunity from liability under any tort principle at all, somehow it had to come under Section 230, where Congress came under, it became in charge of this versus, say, common law judges figuring out where that line was and how much responsibility belonged to so and so versus so and so. And I think that's the problem, really, that Congress says it's it is their ability to either give or take away this power. And then, as you say, and as we've talked about previously, they use this as a carrot or a stick to get these behemoth platforms and other internet service providers to behave according to their
Yeah.
wishes.
But see, I think, Amy, that the statute really betrays an ignorance of how the law works. Even if you are a platform and you just say, yeah, like anybody can post on it, you do
Mhm.
no scrutiny, anybody can post on it, you will not be liable for defamation because it requires at least negligence. That is,
Right.
you didn't exercise due care. Well, you could say, this is the standard in the industry, so to speak. Or, you knew that it was defamatory and did nothing. If you just hold it out there and don't do anything, you're not going to be liable because you're faultless. Defamation is not a strict liability tort. And so it's the same way. Okay, the municipality has a park. If somebody puts a defamatory sign on a park, the municipality is not liable for it. It says, hey, anybody could do that. We didn't have any notice. We weren't conspiring them or anything like that. So I think that this idea that without this liability immunity, my God, all these lawsuits would be filed and they'd go bankrupt was just phony because they didn't really understand how the law works. Aside from the
Right.
fact that very, very few people ever file suit because it calls attention, to the defamation and gives it, an extra megaphone that otherwise would just go away,
Yeah. Yeah.
because most people would forget about it. So I just think the whole idea of 230 was made up out of whole cloth and not understanding how the law actually operates and how you have to have a mens rea in order to be held liable in these circumstances.
Yeah, the only question in my mind is now with the advent of all types of content scanning, analyzing, surveillance technologies that these platforms do. I mean, all you have to do is post the wrong word on Facebook or even Twitter on X. You post the wrong word and suddenly your post is demoted, it's throttled so that not as many people see it. And that is all done automatically because of these scanning technologies that exist. And so the question in my mind would be if there's no Section 230 to dictate to the platforms what is a reasonable, ordinary business practice for a social media platform so that they can escape liability, which is what 230 does, right? Um, if the tort law was doing this, and then it would be up to the courts to set precedent as to what a reasonable business practice would be. Would the courts end up mandating by default these very invasive scanning technologies? Because again, going back to our favorite topic that we're going to discuss someday, the third party doctrine, right? This thing that's behind, if the platform scans the content and has access to a record of the types of things that you post, and it's all associated with a profile that they've created about you, which we know Facebook does at least, the government can obtain that without a warrant,
Yeah.
right?
Yeah,
And
absolutely. You get
yeah,
everything that's in third party. But let me go back, I
yeah.
think, Amy.
So I think it's ominous, I mean, there's some ominous things about leaving it to the common law, whereas in the ordinary state of things, right, in a proper free market where the government wasn't engaged in mass surveillance, I think the best thing would be to get rid of Section 230 and leave these questions to the common law. Yeah.
Well, I think that let's think about professions, medical profession, legal profession. How do you set up standards? We're trying to think, say, about defamation, vulnerability of these platforms.
Hmm.
Well, they just do what's customary in the profession. The
Yep.
judges don't decide, and you have an expert. Okay, so if you bring a medical malpractice case, you'd have an expert doctor come in. Well, this was way out. They cut off a leg rather than an arm. That just doesn't happen,
Yeah.
right? If
Right.
you have a legal malpractice case, no, he really overlooked stuff what they should have seen. So if you try to transpose that kind of analysis, to the social media journalism, they say, well, what's the what is the standard in the industry? What's accepted as the norm? The judges wouldn't make it up. They'd look to the industry and get experts. Okay, I'm familiar with it, and this is kind of the level of scrutiny that they give to XYZ. So the law on that score, I think, is flexible. I'm not worried about an overreach on that score. And when it comes to just leaving footprints out there under third party doctrine that lets the government come in and search anything they want or grab it up without any warrants,
Yeah.
I think that's going to operate until the third party doctrine goes away, independent of whether you got Section 230 or not. Um, that's a whole different, mindset that gets us into this huge problem of the surveillance state and no risk existence and all these other things.
Okay, so I look forward to hearing how the court rules on these net choice cases involving the Florida and Texas legislation. And then after that, of course, we'll see what Congress does. I know that there's been talk in Congress recently of potentially sunsetting Section 230, saying it's going to expire after a certain number of years. I don't know what the status of that is now.
Yeah, I don't. It seems to me, Amy, that at least at the outset, the argument made, and there was a statute largely shepherded by then Senator John McCain, was, well, it's kind of an infant industry, that it's just emerging, and therefore it's like a baby chick. It needs protection, because it wouldn't be able to survive the legal onslaught. Okay, well, the little baby chick is now a giant. The acorn has grown into a giant oak. And that's clear to everybody. So even assuming at the outset this was needed, it's clearly obsolete.
Right.
It's like the motor vehicle age, trying to go back with horse and buggy type of rules. It doesn't make any sense at all. And why sunset? How much larger do you want to get these companies to be before you take away the training wheels on their bicycle?
Yeah, no. And so many of them became larger during the COVID era, so there was that as well. So yes, there's, as far as I can tell, plenty of resources there to fight any legitimate lawsuits, and it might make them think twice or three times before automatically censoring or even enhancing the engagement of certain types of content on their platforms.
Yeah.
Yeah.
But I think that it is a very challenging problem, I believe, when you're trying to balance the right not to associate with ideas with the right to actually express ideas. Drawing the line between the two is not easy, and both of them are totally legitimate free speech kind of claims. And oftentimes people are only looking at one side of the equation. Well, they shouldn't be able to censor X, Y, Z. Say, wait a minute, in your own life, you censor people all the time. You don't invite anybody in. You don't have open parties, party crashers and come in and say whatever. You say, well, I'm only going to invite people to my home who like Mozart, or don't like people who like George Washington, or don't like people who like Trump or whatever. And you assume you have that right, without even thinking of 5 seconds about it. But suddenly when you get in social media, well, they shouldn't have that right. Well, why? You should be able to come up with an explanation. And that's not an explanation that I can think is very clear.
Well, but you are in favor of this company town rationale from the Marsh case that we talked about starting yesterday, right?
That is right. I think that's a fair statement. But of course, it would apply, once, remember in the Marsh case, the corporation was the town. It wasn't like it exercised maybe a little bit, everything, the house, the sidewalks, the water, everything. So it performed the functions of a municipality. And so when you have a social media platform that is so large that it's performing the functions that were previously performed by the sidewalks and streets and parks, where you could demonstrate at that stage, viewpoint neutral. That's what you've got to be, again, without prejudicing the right to kick off anything that's illegal, because that's viewpoint neutral, because you're not only permitting some illegalities to there, not others.
Now, it's been a while since I've looked at the Florida and Texas laws, but as I recall, both of them have a cutoff so that they would apply only to social media platforms of a certain size, right? They have to be big. And so isn't it possible that the court might embrace something like what you are talking about with respect to those larger platforms and uphold one or more of these two state laws?
I mean,
I know, for example, sorry, just one more thing. Justice Clarence Thomas I disagree with him actually, and I disagree with this whole rationale that you're talking about, by the way. But he has spoken out in favor of treating these platforms as common carriers, which is essentially what you would be doing, maybe under a different type of rationale with this company town analogy, right?
Well, that's right. You would have to be you're treating them as like telephone companies. Okay, anybody can pick up a phone and use it, even if it's to place an illegal bet or something like that, right? You just go
Mhm.
ahead and use the phone, and the company is obligated under common carrier to anyone who pays. They can't discriminate
Right.
on that score. So that's what you would have to analogize the social media companies to, and it seems to me that's not a bad analogy. But it would be uniform. Remember that if this public electronic square doctrine, if you will, comes into play, it would apply nationwide, not just Texas and Florida.
Sure.
I don't I think that social media is clearly interstate commerce. They wouldn't let it be a state by state regulation because you couldn't operate,
So
right?
there'd be a good chance that the court would say something positive in favor of the kind of rationale that we've been discussing here, the sort of company town type rationale or common carrier rationale. But then they would say this is not the state's place to do this. If Congress wished to do it, then it could, et cetera.
Yeah, I
Federal
think
Congress, yeah.
it's possible. It's something like that. Yes,
Okay.
because
Okay.
you couldn't operate the internet in a way that had
I'm telling you, they're
everything
trying to
done.
do it with respect to privacy, right? So California has its CCPR, or whatever the current, instantiation of that is, but they all have their state privacy legislation. I think it's California, Nevada, maybe Virginia has it. Different states have enacted their individual privacy regulations, and that's getting a bit onerous for online websites and platforms to deal with.
Yes, and I think at least at present, Congress has not done anything to try to preempt what the states have done. And there may and I don't think that the case is closed on saying that's an undue burden on interstate commerce under the Commerce
Mhm.
Clause. So
Right.
I think that's still an untested domain. But you're absolutely correct. That does, and you have different standards over in the European Union. You have in the United States on data
Yes.
protection and privacy protection. So I do think that if Congress wanted to endorse the states doing this, I think it would pass constitutional muster. If it doesn't, then it becomes, I think, much more challenging to say that you can have this balkanized state regulation. But I'm not a technological expert. I don't know how much a network could tailor, its uh, policies, to protect privacy more in one state than another without abolishing up the whole network. But if it's just a matter of, hey, you can't sell the information there, that's simple to police at the state. If you have a California customer, you just can't transmit its data. Period. It's private. But if it's easy to segregate customers state by state, it wouldn't be difficult. But I don't know enough about the network to know whether
Yeah,
that's
I mean, it depends how much actual surveillance and data gathering that you do about the people who visit your website, right? So there is a burden there, how high it is. And, again, the larger companies, of course, are more capable of complying with regulations like this. It doesn't take too much out of their budget, et cetera. So that would be your prediction then, that the court is going to strike down these two state laws in the net
yes.
choice cases. Okay. 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 So we've covered all the cases. Is that correct? The ones that are
Yeah,
upcoming that we're
we
waiting for.
covered all the cases today. So we've got 6 left on the docket, and they could release them all tomorrow, or they could carry at least some into Monday.
And you haven't seen any sign of them carrying them into Monday yet. Maybe they want to have
Not
their
not
weekend.
not yet, not yet. But
Okay.
the court, they run their own rules. So
Right. Right.
it
Okay.
you could get that.
So we'll go ahead and draw a line here then, and we'll look forward to speaking with you tomorrow, same time. So again, that's 11 Eastern. Everybody come back to BitChute, main BitChute channel, or wherever you're watching this now, because we have been multi-streaming these broadcasts. But if you want to hear these important cases still coming up. I mean, I would say both of these are actually three of them quite important. Well, four of them, all four of them. Actually, yeah. Sorry, as I think of it, I really want to hear. It's going to be a lot to release in one day if they do.
It would, and that's why they're reluctant, because some of the unimportant case may get kind of buried. I think it would also be useful for our audience. I think it's the last day of the term to kind of do kind of a roundup of where the court showed itself to be on the political spectrum, the philosophical spectrum, and what's likely to happen to the court based upon the 2024 presidential election, if anything. Are there going to be any vacancies? Anyway, we can do a little bit more than just the cases there, because we have a little broader perspective at that point.
Yeah, and then the recent opinion poll that thinks that the court is too politicized, and is that really true, and et cetera, right?
Right, exactly.
Right. Okay, that sounds good. Thank you,
Okay,
Bruce.
thanks,
Talk to you
Amy.
again tomorrow.
Okay, bye-bye.
Bye.